Good afternoon, financial professionals. My name is Jennifer Nadeau, case design specialist here at E4 Insurance Services, welcoming you to The Brew, building relationships every week. Thank you for tuning in today. For those of you joining the Brewcast for the first time, welcome. We like to start the Brewcast by celebrating what today's national day is. And today is National New York Day. So hello to our friends in New York. It is also National Chai Day. And last but not least, depending on how you say it, it's National Pecan Cookie Day or Pecan Cookie Day. So little pecan cookie and some chai might be good. On today's brew, we welcome Susan Johnson-Drenth, certified law attorney with JD Legal Planning, for a special 30-minute brewcast. Susan, Attorney Sue, is going to be talking to us about special needs trust. And she practices law in North Dakota and Minnesota. She has been named as a Great Plains super lawyer every year since 2015. Sue is a fellow in the American College of Trust and Estate Council and is the former state chair for North Dakota. Sue is also the chair of the Elder Law section of the State Bar Association of North Dakota. She is the only certified elder law attorney in North Dakota and northern Minnesota. In addition to practicing law, Sue continues to hold licensure as a registered nurse as well in North Dakota. She received her Bachelor of Science degree in Business Administration and her Associate's degree in Nursing from North Dakota State University, and she graduated with distinction from the University of North Dakota School of Law. Before we get started, I would like to remind everyone to please feel free to use your chat box as we go through our session today with Attorney Sue. And also, all attendees are in a drawing for a prize, and we will be announcing that winner at the end of the call. Good afternoon, Attorney Sue. We are so happy to have you with us today.
Thank you so much, Jennifer.
Before we get started, now you're here to talk with us about special needs trusts, and there's some statistics that you had shared about the number of children in the United States that have a disability and why special needs trusts are so important. I was hoping that you could kind of take a step back before we specifically got into special needs trusts and just level set and give us some trust basics before we actually get into special needs trusts.
Sure. Well, a trust is a separate entity. It can be formed either through the language in someone's will, or it can be a separate trust that you sign, sometimes called a living trust or revocable trust, or sometimes in the event of a special needs trust, irrevocable trust. But you name a trustee, and usually there's going to be backup trustees in case the original one can't serve. And then you're going to name primary beneficiary, contingent beneficiary, and then set forth guidelines on how the trust might be used over time for those individuals.
Okay. So when it comes to special needs trusts, and let's get into that now, there are two types of special needs trusts, correct?
Correct. And what's so important here with all the professionals that may be involved in watching today on Brew is I want to help put a little seed in your brain. So then when you're helping families, if you hear that they've got a child who's on the spectrum, or a child who has a disability, or a child with Downs, that you remember to let them know that a special needs trust is an option for them rather than disinheriting that child.
Mm-hmm.
All 50 states have special needs trust law, and there's also a federal special needs trust law. And those are the two different types, either the one that's born out of federal law or the one that's born out of state law. And it's a bit complex for a short presentation, but essentially one is the type of trust that you would use as an inheritance. And that would be the state law type of special needs trust, also called a supplemental needs trust in some states. And then the alternative is the federal law for special needs trust. And that would be an individual that perhaps was injured in an accident and receives a settlement as a result and has left with a catastrophic injury, they're on government benefits as a result of that injury, and then they're coming into money and they're being told you can't be on government benefits unless you have less than $2,000 in assets, but yet maybe they're getting a $500,000 settlement, and they want to be able to have that money for a while rather than losing their Medicaid eligibility. And so those are essentially the two types: the one that's created under federal law with the individual's own assets, which does require state payback for any Medicaid received when they pass away. So that's a lesser alternative. Or the state type of special or supplemental needs trust that a parent or a grandparent might leave for an individual with a disability. And when the individual with a disability passes away, there's no state payback. Instead, it can continue on for other individuals. And that would be the most optimum type of estate plan.
Okay. When I've listened to you before and read some of the information that you share, I know that you've talked about a third party special needs trust, and thank you for talking about state and federal, and I definitely made some notes there, but could you talk to us a little bit about the third party special needs trust? What is it? How does it fit into what you described, and what can it do?
Sure. A third party special needs trust would be the one created under state law.
Okay.
And so that's what I call the platinum alternative. It does not require state payback. Let's say that I had 3 children, one who has Down syndrome and who's 25, and will always need lifelong maintenance of his inheritance because of his Down syndrome. And he's going to be receiving Social Security benefits based on his disability as well. He's going to be receiving Medicaid or medical assistance, whatever it might be called, in his specific state. Well, I have a choice. I can either disinherit him or I can leave his inheritance in a special needs trust. That would be a third party special needs trust, because as someone who, the assets being used are the assets of a third party. They weren't my son with Down syndrome. He did not own those assets. Instead, I elected to give him some inheritance in a third party special needs trust. In some states, it's called a supplemental needs trust, such as Minnesota, and name a trustee. He would be the primary beneficiary. And then upon his death, his last expenses could be taken care of, and then ultimately have it distributed maybe to his siblings, to his cousins, maybe to a charity, whoever I elect as the contingent beneficiary. But when assets are in a third party special needs trust such as that, as long as it's written properly and managed properly, that's key because there's rules on how that's done. But as long as it's managed properly and written properly under the state law where he's a resident and receiving benefits, then the assets of that trust and the distributions that it makes on his behalf count as zero against his eligibility for his government benefits. It does, because he does not own them. He's merely a beneficiary of the trust. So he stays and retains his eligibility for his medical assistance, for any community support services, for any SSI or supplemental security income. So the third party special needs trust is ignored. And that way he can enjoy his inheritance just like his siblings.
Excellent. Thank you for that. And again, reflecting back on some of the information that you had shared before that I've listened to, the other type of trust is a self-settled special needs trust. Am I saying that correctly?
Right.
Could you talk to us a little bit about that now?
Sure. And for anyone who has a pen, if you want to write it down, it is a federal law. So it's under the US Code, and it's 42-1396 PD4A. So 42-1396 PD4A. So P like Paul, D like dog, 4A. And this is the federal law that's been around for more than the 25 years I've been practicing law, that says if an individual has been determined disabled by the Social Security Administration, so not just if the family decides someone has a disability, but an actual finding from Social Security Administration that they're disabled, then if they have money, assets, land, shares in a company, whatever it might be, that are causing them to have too many assets to qualify for, say, medical assistance or Medicaid or other community support services, they can take those assets prior to age 65 and move them into a self-settled special needs trust and have someone other than themselves manage it on their behalf. It's an irrevocable choice. And once it's in the special needs trust under a tax ID number, not their social security number anymore, then the state and federal government will ignore those assets as far as counting them for eligibility. The downside of it is because those assets were owned by the individual with the disability themselves, it's self-settled, it's their own assets themselves, then there's a state payback clause required under federal law. So any Medicaid received or medical assistance received by that individual before it goes to anyone else at death must go back to pay any state medical assistance programs to repay the taxpayers for providing those benefits. So you can set it aside. If you use it before you pass away, great. If you don't, then it goes back to pay the medical assistance system. But a proper inherited trust, a third-party special needs trust with someone else's money does not have that requirement.
So if I think about estate planning, and it was one of my questions, and I think you just answered it, but if there's anything to expand upon, which is the best option for estate planning, would it be then the third party special needs trust, because there's not, and I'm going to say it like this, incidence of ownership, if I'm saying that correctly too, so that it can't be pulled back with the disability benefits?
In the parlance of insurance, that's a great way to put it, Jennifer.
Okay.
In that the individual never actually owns it. And sometimes parents who have a child with a disability, or grandparents or whoever it might be, might name that child with Down syndrome directly in their own name as a beneficiary. So if I had 3 children and my middle child had Down syndrome, if I just listed him in his own name as a beneficiary of a $300,000 life insurance policy, when he inherits that in his own name and social security number, he's going to have way more than the $2,000 asset limit. And so at that point, after he acquires it in his own name, or when it's on the way to go to him, even before it's claimed, sometimes we have to do a self-settled special needs trust just to kind of put the pieces back together. But it's the lesser alternative. We do it so that he can maintain his eligibility for his government benefits. But because the parents didn't do a proper estate plan before he died and did a third-party special needs trust and had the insurance going to the third-party special needs trust, we have to put the pieces together after the parents have died. The best alternative is a payback trust. Mm-hmm. So if he doesn't use up that $300,000, then it's going to be state payback. But had the parents done a proper estate plan, they would have, number one, in their will stated that the share for the child with a disability would have gone over to a third-party special or supplemental needs trust. Number two, they would have signed a freestanding third-party or special or supplemental needs trust the same day they signed their will, and done nominal funding, like opened up a $100 checking account in the name of the third-party special needs trust to get it going. Get it reported to Social Security, get it reported to Medicaid, so that those systems know that this child is a beneficiary. And then specifically on any qualified retirement accounts, annuities, life insurance benefits, transfer on death arrangements on non-qualified investments, pay on death designations on bank accounts, instead of listing the child in his own name, you list so-and-so as trustee of the son with Down syndrome, irrevocable third-party supplemental needs trust, and its date, and then the tax ID number. And then the individual with a disability never vests or has incidence of ownership of that asset or of that money. And instead it goes straight to the trust. And then it's managed and used to maybe supplement, give them a better apartment, give them more care than the state provides, give them travel opportunities, provide for clothing, electronics, communication devices, and cell phone, internet, whatever that individual needs. that's not otherwise paid for by a government benefit. And then when they pass away, it ultimately goes to someone else. So it's a great way to help supplement their life, just like the parents did while that child was when
Mm,
they were living. It
mm.
continues on, so the parents can support that child even after they passed.
Excellent. Thank you for that. And as I'm listening to you, and you mentioned it right when we opened, it's a lot of information to
Mhm.
share in a very short period of time. And I'm thinking of it from my own perspective right now, and also from our advisors' perspective, as far as, okay, we talked about the two different kinds of trust. We talk about state and federal, right? And I'm just trying to now, my question is there an easy way or a simplified way, if we're trying to summarize this in our minds, of the differences between the two? Is there a Reader's Digest version of how to kind of delineate that in our own minds?
Sure. So the cliff notes would be when you're meeting with your clients as advisors, there should be in your intakes a question: are any of your clients' descendants, so their children or grandchildren, are any of them disabled or have a progressive illness where they may become disabled? So it
Mhm.
begins that conversation, because otherwise it really doesn't come up. As the attorney who was a co-drafter of the special needs trust law for the state of North Dakota back in the 90s, it has been on my intake forms for a long time. And it's, we've heard the statistics of the number of individuals that are on the spectrum, especially young boys. And you can't go a day, it seems like, at least in my office, without finding someone who has a loved one that's affected by a disability, whether
Mhm.
it's an adult child or a young child or grandchild. And then share the information that, did you know that you might want to talk to your attorney about doing a special needs trust? And don't worry about the terms, because it's different in every state. When you're talking to your clients as advisors about how they're leaving their estate plan for family, the only type of trust you'd be talking about is a third party special needs trust. And so you can mention that they can talk to their attorney to have these trusts set up. Grandparents can do it for grandkids. They don't have to wait for the children to get their wills done, because sometimes, kids in their 30s and 40s, that's not their priority. Grandparents can create it for them. It can be any third party. It could be a neighbor. You don't even have to be related, but just someone's got to set this trust up so that it can be used and named as a beneficiary in documents, as a beneficiary in a will, and as a beneficiary in a revocable living trust, as a beneficiary on a policy or on a product. And just mention that that's a better alternative than leaving an individual with a disability money, because that may screw up their life. That may screw up their community supports.
Mm.
And it's better than disinheriting them, because if you disinherit them, sometimes people have a device where they think, oh, well, I'll just give everything to my two children who don't have a disability, and they'll make sure to take care of their brother with a disability. Sometimes those best laid promises go by the wayside. Sometimes the county will determine that to even be a violative type of arrangement. And so it's better to just legit do it. All 50 states have it. If, however, a client tells you their child was on benefits and then came into this lump sum Social Security settlement, or a car accident settlement, or has an illness and has lost their health insurance and isn't getting much help from the state and would like to get medical assistance, but they have too much money, then you might want to tell them that they can do, if they've been determined disabled by the Social Security Administration, they can set aside their assets in a special needs trust, whether it's a physical or cognitive or mental disability. They have that benefit, and it's unique to them because they have that finding of disability. None of us who don't have that finding are even allowed to do this. And so, but then they can maintain or obtain eligibility for government benefits. And so if you're talking about estate planning, you're talking about, let's set up a third party special needs trust so we can include that individual with a disability,
Mhm.
and talk to an attorney who's done them before. If they talk about an individual who has a child or loved one who's lost their benefits, then maybe setting up a self-settled special needs trust to set aside those extra assets. But you need to be careful because there are some forms that attorneys can use on online software that a lot of attorneys subscribe to that really doesn't comply with state law or the interpretation that states have. And so any attorney can find some software and fill it out. When you're talking about an attorney doing a special needs trust, what I recommend to people, there's a lot of attorneys who do them and do them well in all 50 states. Have they written them before? And after they've written them, did the person actually qualify for medical assistance? So not just can they write one, did it actually work? And those are the questions that you want to find out. Because anybody can write up documents and say, hope that works for you, bye. But have they actually seen and managed a trust, a special needs trust specifically, whether it's either kind, because they're managed the same way. But they've been there when people have questions of, can I use the trust to pay for this? Can I use the trust to pay for that? Because somebody actually has money in a trust. And now how do they advise people when that's happening? So you want an attorney that's seen it from the beginning and seen it from the end.
Excellent point. And one that, I wouldn't have thought of. Go to my attorney, ask if they know what a special needs trust is. Of course they do, but to actually ask if not only have they written one, but did it work is so important. So thank you for that. We're at 20 after the hour. I think what I'd like to do now is just open it up for questions. Do you have any parting comments, Attorney Sue, before I do that?
Nope, not at all.
Okay. While we're giving some folks some time to open up their chat box and ask questions or comments, I'd like to remind everyone that the library of all of our brewcasts are available on E4's website, and that's www.e4.insurance.com. You can watch the replay of this one as well. And let's do our drawing too while we're waiting for people. Attorney Sue, if you could pick a number between 1 and 15, we'll have our winner.
13.
Lucky number 13.
My favorite.
That is Mark Allen Davids. Congratulations. Be on the lookout for a CE voucher and also a Starbucks gift card coming to you from all of us at E4. So congratulations. Certainly was just a wealth of information, Attorney Sue. And I know that I speak for a lot of people. We're so grateful to have you on the call, and also for your dedication to what you do, not only with Special Needs Trust, but for elder law as well. So important. And I know that you're very much appreciated in the community as well. So we really thank you for taking the time to being with us today.
Absolutely.
Yeah, that will conclude our call today. Tune in next Wednesday as Melissa Finnegan, Vice President of Training and Development with Lincoln Financial Distributors, presents on the topic of breaking through the noise, the art of communication. Melissa will focus on sharing with attendees how to ask for an introduction artfully, the importance of doing your homework before a meeting with an advisor, words to use and words to lose, and also best practices for emails and how to leave an effective voicemail. So a lot of great communication tips we'll be getting next week. So we look forward to having her. Thank you again, Attorney Sue, for being on, and we will see everyone again next week on The Brew. Thanks so much for watching today.